Welcome to the second in our series of public preview lectures introducing the University of Arkansas's Honors College Signature Seminars for spring of 2022. My name is John Treat. I am the Director of Interdisciplinary and Curricular Learning at the Honors College, and I'm welcoming you on behalf of our Dean, Linda Kuhn, who is on the road in Tennessee this evening. Tonight's lecture, Economic Thought and Competition Law, is presented by Professor Sharon Elaine Foster of the University of Arkansas School of Law. Professor Foster has been at the University of Arkansas since 2000. Prior to her arrival, she was an attorney in private practice in Los Angeles, specializing in international law and construction law. She earned her bachelor's degree from UCLA, her JD from Loyola University, and her LLM and PhD from the University of Edinburgh. Tonight, she will be taking us on a journey through competition, more commonly known as antitrust law in the United States, from ancient times through the Middle Ages in what promises to be a fantastic seminar this spring. We join the lecture.
It's interesting to note that Adam Smith, the author of The Wealth of Nations in 1773, and according to some, the father of economic theory, was a lecturer in philosophy at Edinburgh University and was the head of the moral philosophy department at the University of Glasgow. We're going to be studying this moral philosophy, both in the ancient period and in the Middle Ages. What is the historical method that we're going to be looking at? Well, the historical method, primarily, we're going to be taking a look at primary sources. We're going to be taking a look at secondary sources. We're going to be taking a look at the archaeological record, and we're going to synthesize all of this information. Now, primary sources, most of you probably already know, are sources of information that was created at the time under study, such as manuscripts and artifacts. We'll be studying several reform codes, statutes, and cases from the relevant time period. For example, from Mesopotamia, we'll be taking a look at the reforms of Urkagina, dating back to about 2350 BCE, the laws of Lipit Ishtar, dating back to about 1860 BCE, and of course, the Code of Hammurabi. But this history is not limited to constitution, codes, reforms, and case law. We'll also study stories from the particular time periods, such as the dreams Joseph was called upon to interpret for Pharaoh, found in Genesis, which dates to about 1200 BCE. Political science sources, such as Aristotle's Politics and St. Thomas Aquinas's Summa Theologica. The ancient Greek play Plutus by Aristophanes, which dates back to 446 to 386 BCE. And poetry, such as Piers Plowman, written around 1370 by William Langdon. These sources give us an idea not only about did they have competition law, did they have laws against monopolies and cartels in the ancient period and in the Middle Ages, but what were the economists of that time period thinking about with respect to these laws, with respect to should we even have laws about monopolies or about cartels? We'll also take a look at secondary sources, which are works that analyze, assess, or interpret a historical event, era, or phenomenon. We'll be reading excerpts from some books, journal articles, and research projects in our secondary source reading. And the archaeological record. This would include artifacts, built structures, human impact on the environment, and my favorite, garbage, as well as other sources in the archaeological record. We will examine some photographs of artifacts, such as the cones of the reforms of Urkagina and the personifications of the seven deadly sins with particular attention to the sin of avarice, depicted in manuscripts and other art forms. Synthesis, having studied the primary sources, secondary sources, and archaeological record, the students will synthesize these sources in a final paper. So taking all of these sources that we've looked at, discussing them in class, and then taking that and putting it together to see, well, what did economic thought in the ancient period or in the Middle Ages, what did it think about with respect to the competition law that we are studying? Now, some terminology will also be helpful before we start looking at some of our sources, primary, secondary, archaeological, because the terminology in competition law is not necessarily simply terminology that we're used to, like monopolies or cartels, unfair trade practices, and so on. The terminology that is often comes up in the historical record includes terms like forestalling, regrading, and engrossing. Now, these laws, these acts, come from what has been described by some scholars as the middleman laws. And some scholars have dated these back to around 1200 CE in England. But what we find in the historical record is actually this terminology dates back much further, and we will see these terms being used in some of the ancient records. Forestalling, for example, was simply meant when the farmer harvested, say, his grain, he would take his grain then to the market to sell. But if someone stopped him on the way to the market and said, I'll buy all of your grain from you, you don't need to take it all the way into the market and sell it. Sell it to me here, go back to your farm, continue with your work. That person forestalled the farmer from taking the grain to the market. And of course, after buying it from the farmer, would then take it to the market and sell it at a higher price. Regrading was a practice where once the particular good was at the market, once again, using our grain analogy, farmers got the grain at the market, someone would buy up all the grain from the farmer at the market and then turn around and resell it at a higher price. And engrossing was basically monopolizing, buying up all of a particular good so that you could be the only one to sell it and sell it at a higher price. And it was thought that these middleman laws basically did nothing but enhance price. Of course, later economic thought on this would question whether or not that was indeed a bad thing, because, hey, isn't it more efficient if the farmer isn't also having to do all the transportation? But these are the terms that we might see in some of our research, taking a look at the historical record. With that in mind, we start with the ancient period. And the ancient period, we start with, to the left, you see the Code of Hammurabi and Mesopotamia. We go through various periods, including we take a look at Hebrew law, certain parts in the Bible, the Talmud, the Torah. We take a look certainly at ancient Greece, starting with Hesiod, actually, in his Works and Days, taking a look at some Homeric hymns, like the hymn to Hermes, taking a look at some ancient Greek plays, as I mentioned, such as Aristophanes, Plutus, as well as taking a look at Aristotle's works that many of you are familiar with, including the Politics and Ethics, and then end in the ancient Roman period. Economics of justice and competition law in the ancient period. Well, the ancient people may not have developed a science of economic theory, but they did produce considerable economic thought. Economic thought is reflected in religious beliefs, morals, ethics, and is evidenced in the ancient records of laws, myths, plays, and other writings. The written evidence from the ancient period indicates economic thought in general and competition law specifically focused on fair and unfair. It focused on virtue and vice. The reforms of Ercogena give us a wonderful story with respect to competition law issues. Ercogena was a ruler of the ancient city-state of Lagash, located in Mesopotamia. His reforms may be the first recorded example of an attempt to combat the accumulation of wealth in the hands of the few, which is a terminology that we see even today in modern antitrust case law by the Supreme Court of the United States. Wars with neighboring city-states economically weakened Lagash. And in order to pay for these wars, revenue had to be raised, primarily through taxes on the poor and the middle class. By the time Ercogena came to power, Lagash was considerably weakened and already in the throes of social and political turmoil. Some of the reforms were competition related, primarily by state price controls, which would limit the ability to charge monopolistic prices, particularly relating to necessities such as food. Ercogena's reforms also reference the practice of engrossing, a monopolistic mechanism with respect to grain in this case. Ercogena's reforms were intended to restore economic justice, but they did not last long. Lagash's neighboring city-states attacked and conquered Lagash, and the old pre-reform ways returned. Some have postulated that Lagash's demise was due to its weakened state caused by years of economic abuse and corruption. Others speculate that the fall of Lagash was due to the wealthy of Lagash colluding with the other city-states to depose Ercogena and regain their power and wealth. What is true or fiction, we may never know, but we do know that the issues identified in the forms of Ercogena, including anti-monopolization, were important enough to chisel in stone for posterity. We see in Hebrew law, in Genesis in particular, that the dreams that Joseph interpreted for Pharaoh may be a story about a grain monopoly. You might recall that in the dreams of Pharaoh, Pharaoh dreamed that there were 7 fat cows and then dreamed that there were 7 skinny cows, and the 7 skinny cows evidently consumed the several fat cows. And Pharaoh also had a dream that there were 7 healthy grain stalks and 7 shriveled grain stalks, and the shriveled consumed the healthy. Joseph interpreted this dream for Pharaoh that there would be 7 years of great plenty throughout the land of Egypt. This will be followed by 7 years of famine, and all the plenty would be forgotten in the land of Egypt. The famine would consume the land. As the monopoly interpretation goes, after interpreting Pharaoh's dreams, Joseph was made a royal grain dealer in Egypt by Pharaoh. When wheat was plentiful, Joseph bought it up, no doubt, at a low market price due to the large supply. When the 7 years of plenty were over, the 7 years of famine started, and people came to Joseph as the sole source of supply. Joseph sold them grain at prices so high that during the first year of famine, the people paid all of their money to the monopolist. During the second year, they paid for the grain with their horses, their flocks, their cattle, and other livestock. And finally, in the third year of the famine, the people traded their land and sold themselves into slavery to the Pharaoh. The monopolist saved the people from dying, but at the cost of the transfer of all of their wealth to Pharaoh and a life of slavery. Another source that we find in the Bible is in the book of Amos, dating from around 750 BCE. The prophet Amos, as a historical figure, dates back to about 750 BCE. He delivered an economic justice message as an admonition for failing to follow the laws of God. People were disposed of their land in Israel when the wealthy class, enriched by the monarchy in exchange for their loyalty, foreclosed on the poor who were unable to pay their debts. Amos voiced three critiques against the wealthy. First, that their life of luxury was itself a sin. Second, the wealthy class lacked compassion for the poor. And finally, the wealthy class lacked a sense of justice for the poor. Now we find this in Amos 8.5, where increasing the price of wheat, basically making the bushel small and the price, the shekel, great, coupled with fraud, such as falsifying the balances by deceit, was an unfair wealth transfer that concentrated wealth into the hands of the few. The Talmud cites to Amos 8:7 as the authority for the condemnation of forestalling. So we see in the book of Amos, we see this concept of wealth transfers, which have ultimately been interpreted in the Talmud as a condemnation of forestalling, which we looked at earlier, the practice of basically stopping the farmer on his way to the market so that you can enhance price. This takes us to the ancient Greek period in this presentation, which once again, I've indicated I'll be talking about Hesiod, Plato, Aristotle. We'll also be talking about the Homeric hymns and certain ancient Greek plays. An example of competition law in the ancient Greek context, we see in Aristotle's The Politics, two examples of a monopoly. The first example is the example of Theos the Milesian. And there is an anecdote in Plato's Politics where basically he tells us that, that Theos and his financial device, which involved a principle of universal application, but is attributed to him on account of his reputation for wisdom. Theos was reproached for his poverty, which was supposed to show that philosophy was of no use. According to the story, as told by Aristotle, he knew by his skill that the stars, while it was yet winter, that there would be a great harvest of olives in the coming year. So having little money, Theos gave deposits for the use of all of the olive presses in Chilos and Miletus. This seems to be a renting on margin because he didn't evidently pay for it all at once and up front, but he did rent them. He paid for their use ahead of time. He hired them at a low price because no one was bidding against him at this time of year. When harvest time came and many wanted the use of these olive presses, Theos let them out at any rate which he pleased and made a quantity of money. Thus, he showed the world that philosophers can easily be rich if they like, but their ambition is of another sort. He is supposed to have given a striking proof of his wisdom, but as Aristotle tells us, his device for getting wealth is of universal application and is nothing but the creation of a monopoly. It is often practiced by cities when they are want of money. They make a monopoly of provisions. So that's one example that we see in Aristotle's The Politics. We also see an example in the Politics, as told by Aristotle, of a man of Sicily who, having money deposited with him, bought up all the iron from the iron mines. Afterwards, when the merchants from their various markets came to buy, he was the only seller. And without such much increasing in the price, he gained 200%, which when Dionysius heard, he told him that he might take his money, but that he must not remain in Syracuse. for he thought that the man had discovered a way of making money which was injurious to his own interests. He made the same discovery as Thales. They both contrived to create a monopoly for themselves. And indeed, the term monopoly comes from the Greeks, from the sole seller. So it has definitely recorded in history as a practice, and what was thought of that practice we see later on in other works of Aristotle. For example, in the Ethics. Ethics basically provides us with an early application of price theory, where price is determined by supply and demand. Fairness appears to have been a subjective standard determined by demand, which in turn formed the foundation for just price theory, extensively explored in the Middle Ages, and which we will be exploring, and what is basically today's fair market value. So price theory, which is very prevalent in economic theory, is something that we can trace back at least to Aristotle. And indeed, we may see some elements of it in supply and demand theory in some earlier pieces as we go through the historical record. Just price, based upon my experience, has been given an unfair reputation as being a just price based strictly upon morals, and a just price as determined by, say, the church. And to some extent, some have believed that just price is something like a price that has been set by the state, as in fixing the prices by the state. But actually, when we go through Aristotle's Ethics, and when we go through some additional materials in the Middle Ages, we'll see that just price is basically what the seller and the buyer agree to: freedom of contract and fair market value, with, of course, some exceptions. Same kind of exceptions we see in modern day contract law with respect to overreaching, deceit, fraud, and things like that. But in a market free from those types of improper market practices, we see that just price is basically a fair market value. We'll also take a look at ancient Greece competition laws. Now, we don't necessarily have a record of competition laws like a code or statutes, but we see them quite often in the orations. For example, in Lysias 22 against the corn or grain dealers, where profits were limited so that in times of shortage, monopoly prices could not be charged, where creating artificial shortages to raise prices was illegal, and that corn dealers creating cartels was also illegal. So when we take a look at some of these competition laws, we will find them from various sources like the orations. So a quick run through some areas until we get to ancient Rome around 500 BCE to 500 CE. And in ancient Rome, it's critically important because when we get to the Middle Ages, what we'll see is that a lot of the historical record looks back to Aristotle, primarily in ancient Greece, but also we see that it looks back to ancient Rome, where we start to see a codification of the law, including competition laws, laws that specifically deal with monopolies and cartels. For example, Pliny the Elder. And in Pliny the Elder, in his natural history, we see there not necessarily a codification of the law, but a discussion and some economic thought with respect to monopolizations, or in this case, an oligopoly. In Pliny the Elder, we see that he argues that the latifundia, and the latifundia is basically an ancient Roman agricultural estate, and an example of an oligopoly, which is where the land is controlled by a few, or the market is controlled by a few. Pliny tells us that the latifundia have ruined Italy and will soon ruin the provinces as well. 6 owners were in possession of half the province of Africa at the time when Emperor Nero had them put to death. Seems rather extreme. Antitrust law today does not necessarily have the death penalty, but the death penalty was available for violations of competition law in the ancient period as well as through the Middle Ages. So very serious consequences if the law was actually enforced. So Pliny the Elder gives us an economic thought with respect to, is it actually efficient to have most of these resources owned by so few people? We also see some laws with respect to competition in the Lex Julia di Annano, which was enacted during the Roman Republic around 50 BCE to protect against fraud and cartels. It imposed heavy fines on anyone who directly, deliberately, and insidiously stopped supply ships, kind of like forestalling, an act which would increase prices. So we'll see several examples of ancient Roman code law dealing with the competition issues. And then we have the Emperor Nero, who prohibited monopolistic pricing in around 480 CE. Not the first, however, to do so, but we will take a look at some of those codes, including through Emperor Zeno. That takes us to the Middle Ages. And in this slide, you see that we have the canonists, the Romanists, and the theologians. You know, three primary schools of thought that we'll be taking a look at with respect to competition law in the Middle Ages. The competition laws of the Middle Ages adopted some of the legislation from the ancient period, such as Justinian's Code, and tried to reconcile the moral teachings from the church with the economic reality of commerce. The economists of the Middle Ages were interested in a normative approach to economics, the legal and moral aspects of a transaction and evaluation of the system. Prevailing economic thought was expressed by scholastic thinkers who derived much of their philosophy from their understanding of Aristotle and his discussion on exchanges in goods in terms of commutative justice. Of course, in evaluating the system, it was necessary to understand something about how it worked. And while mathematical formulas were not implemented, moral and ethical issues predominated economic thought. The canonists expounded upon canon law, which we'll explore, for example, with the Decretum of Gratian and other sources of canon law. The theologians were focused upon the ancient philosophers and biblical texts, and the Romanists commented upon Roman law. The Corpus Juris Civilis, dating around 530 CE, this was a systematic codification of Roman law, including ancient Roman law, the main parts of which were issued in 533 and 534 CE, during the reign of the Eastern Roman Emperor Justinian. The Corpus Juris Civilis included the Institutes, which was like an introductory textbook, the Digest or Pandex, which were legal debates, and the Codex, which were imperial constitutions and laws. The general concept of a fair price is evident. The Roman law preference was for prices being set by the market under a freedom of contract principle. And one may conclude that this particular freedom, or what was reasonable or a just price, would be an agreed price absent fraud or market manipulation, which included cartels and monopolies. Students will examine parts of the Corpus Juris Civilis that deal with these competition issues, issues relating to monopolies, cartels. Is it a just price? Is it a reasonable price if it is a monopolistic price? Here we see the term turpi lucrum. Turpi lucrum means shameful gain. Some of you may have heard the old saying, about filthy lucre. And indeed, this particularly comes from the idea of shameful gain, turpe lucrum. Monopolistic prices such as forestalling, regrading, and engrossing were considered market manipulation to increase prices and generally forbidden. They were considered turpe lucrum. Under Roman law and considering into modern contract law today, such acts were void, certainly fraud and deceit in modern contract law. It would make the contract an illicit contract and therefore not enforceable. We have a quotation here from the Spanish canonist Raymond of Penafort around 1275 CE. And the quotation is, "Those who at the time of harvest or vintage, motivated by avarice, buy victuals or wine cheap in order to later sell them dear, whether lay or clergy, sin mortally, and it is filthy gain. It is turpe lucrum." Here we see a moral component into competition law. Now, moral component, the motivation by avarice, and indeed, when researching these time periods, because we're not going to necessarily be using all of the terminology we're familiar with today, such as antitrust, competition, monopolies, and cartels. Avarice leads one to find information relating to forestalling, regrading, engrossing, and indeed monopolies. So it was very, very important with respect to economic thought and competition law to take a look at information found in the written record, as well as in the archaeological record that deal with avarice. And basically what Raymond of Penafort is telling us is that if you buy food or wine, especially in times of trouble when there's famine, in order to sell them at very high monopolistic prices, that is wrong. That is a sin. We see that moral philosophy actually continuing on today. Some of you may recall some episodes and some laws against price gouging. So that is something that is a concept that we still see today. Just price, as I mentioned before, is basically the fair market value. Freedom of contract allowed parties to agree upon the contract price, which would be the just price. This agreed price presumably reflected the fair market value. Accordingly, a just price was nothing more than the competitive price fair market value. Just price could include enhanced value due to improvements, labor, and costs, or a government set price. To the extent the contract price was excessive, the contract would be considered illicit, illegal, or void. The concept that a contract was illicit because the price was excessive had its origins in Roman law, known as liaso enormis, where it was an equitable remedy when the seller of land who sold the land for 1/2 or less of the fair market value could have that contract deemed to be illegal or void. Next, we take a look at, in this preview at least, we'll have certainly some gap fillers during the course, but the economics of morality and St. Thomas Aquinas around 1225 to 1274 CE, and in particular, his Summa Theologica. St. Thomas Aquinas was a Dominican friar and a theologian. He's most famous for his work Summa Theological, which is a synthesis of Aristotelian philosophy and principles of the church. The Summa Theological applied Aristotelian reasoning to explain and understand the fundamentals of morality, particularly as set forth in the Bible. This reconciliation of ancient learning and Christian faith in the 13th century, commonly known as scholasticism, and St. Thomas Aquinas was perhaps the most influential of the scholastics. As one would expect from such a synthesis, Summa Theologica addressed some of the competition law issues, famously just price, by incorporating ancient Greek philosophy, biblical pronouncements, canon law, and Roman law. To some extent, the market in terms of a buyer and seller would decide the just price. However, it would be unjust for a seller to take advantage of the buyer, such as in the case of engrossing, to cause monopoly prices for necessities. We see this common thread going back to the reforms of Urkagina, where we'll see this thread about taking advantage of people in dire times, going on now all the way through St. Thomas Aquinas, where we see, again, this taking advantage by engrossing so that you can own all the food, own all the wine, other necessities of life, and charge extremely high prices, monopoly prices. Just price, in a temporal sense, meant commercial transactions for the exchange of goods, where one, there was no fraud or deceit in arriving at the price. Two, the buyer and seller were generally allowed to determine the value of the thing exchanged based upon the market and their own subjective points of view. Three, the price was not excessively high or low in accordance with Roman law principles of laeso enormis. Four, profit was allowed, but not to the point of greed. And five, pricing practices did not harm the community. So again, we see here in Thomas Aquinas's work that what we're looking at here is what some economists today call the perfect competition model. The perfect competition model where all buyers and sellers have equal knowledge, equal access to information. There's no fraud. There's no deceit. That is a perfect competition model. It is something that I personally am not familiar with having seen it ever achieved in human history. But we see St. Thomas Aquinas articulating something that at one point in time later on will be transferred in economic theory to the perfect competition model. The class will also explore the influence of St. Thomas Aquinas on post-Aquinas scholars of economic thought in the Middle Ages. We're also going to take a look at poetry, literature, and the example I give here today is the poem of Piers Plowman. Economic thought and competition law, as represented in literature, plays, and visual arts, will be analyzed. In Piers Plowman, we see to punish on pillories and punishment stools, brewers and bakers, butchers and cooks, for these are this world's men that work the most harm to the poor people that must buy piecemeal. As indicated in this excerpt of Piers Plowman, certain trades had a particularly bad reputation for market fraud. In England, at this time, brewers, bakers, butchers, and cooks had such a reputation, and certain laws were established to counter their fraudulent practices. For example, under Henry III, an act was passed in 1266, prior to Piers Plowman, to fix bread prices according to the price of wheat and ale prices in correspondence with the price of wheat, barley, and oats. These laws remained on the books well past the publication of Piers Plowman, in part due to the public perception that these trades, brewers, bakers, butchers, and cooks, were charging artificially high monopolistic prices. The age of protectionism basically covers the area of around 1300 to 1400 CE. And this is the last century of the Middle Ages that we'll be exploring in this class. It saw an economic downturn during this period, due in part to plague, famine, taxation, and corruption. And these pictures indeed indicate, the plague and taxation of the poor during this time of economic downturn. This contributed to civil unrest throughout Europe, such as the infamous Peasants' Rebellion in 1381. The economic instability not only incited renewed interest in competition law, including laws against forestalling, regrading, and engrossing, but it also instilled a fear in the wealthy class that motivated them to preserve their wealth through protectionist laws, such as laws limiting foreign imports. We see another recurring theme with respect to economic thought and competition law, in particular during this age of protectionism, and that is the idea that if we have economic instability, that will lead to political instability. And political instability is something that the state quite often wants to avoid. And so we see many times throughout history a re-emphasis of competition law in order to try to create some public confidence that these monopolistic prices, that these extremely high prices charged by cartels will not be allowed to continue. This period also sees some great literature, such as Dante's Inferno, around 1320, where hoarders, the avaricious, and spendthrifts are placed in the fourth circle of hell. And you'll notice that Plutus, the ancient Greek god of wealth, is the gatekeeper just before the fourth circle of hell. I found an interesting depiction, not necessarily from the Middle Ages, but this is a picture from the 1800s of Gustave Dore's picture of the fourth circle of hell. Avarice is particularly egregious in times of want, according to Dante's Inferno. And as we see here in this picture, we see these people pushing these heavy sacks of money. And you may recall, and we'll certainly take a look at Dante's Inferno, which discusses this, the hoarders and the spendthrifts are basically pushing big stones or bags of money against each other. The hoarders will push it one way and the spendthrifts will push it back, which also is rather reminiscent of the myth of Sisyphus to some extent. These times of famine, however, do not always result in market intervention with respect to helping the poor and the hungry. In England, the Great Famine in 1315 to 1317 resulted in market failure, evidenced by unprecedented price increases in grain, which may have been exacerbated by the lack of government intervention and by monopolization. So should the government intervene and do something through competition laws and other means, perhaps setting prices so that they could not exceed a certain amount? And actually that practice of price freezing is something that was also used in more recent times under the Nixon administration. So we've seen that price setting or price freezing done throughout history, but it was not done in this time period, which resulted in market failure. And market failure is basically a situation where you may have goods that can be bought, but the people don't have enough money to buy it. And so therefore, they can't buy the goods, the market fails. Also, the Middle Ages provides us with a rich opportunity to take a look at some case law. So, for example, the Orsom versus Plomer case of 1375. This is a case where the defendant was found to have committed market manipulation by fraud. He was also accused of forestalling, but was not ultimately convicted of forestalling. But we see in this case the court defining what the court believes is forestalling. And fraudulent conduct, which he was convicted of, was prohibited under the competition laws of that time. Statutory laws will be looked at, and we have, once again, thanks to the ancient Romans and going on through the Middle Ages, we have some rich sources of statutory law, such as Edward III's law regarding engrossing, monopolization, from 1363. So we'll take a look at some of those sources of statutory law. Interestingly, with respect to statutory law, the Statute of Laborers passed in 1349, and then again, just for good measure, in 1351. This was a statute that was passed because the plagues during this period created a labor shortage, which enabled laborers to demand higher wages. This caused the aristocracy to apply political pressure to pass the Statute of Laborers to limit wages for laborers, limit the laborers' ability to change employers, and require that the laborers enter into long-term employment contracts. Once again, this is very instructive because in our current situation with COVID-19, some of you may have heard some issues with respect to how some people do not want to go back to work at low wages and are demanding higher wages. And we're seeing an uptick in wages for a lot of positions where a minimum wage was all that they could get. So we're having a bit of a labor shortage here after the COVID-19, or we're still in the COVID-19 situation. And then, of course, we're going to take a look at guilds. Now, guilds have been around for many years before the late Middle Ages. And during the early years of the guilds, they were governed by local laws, market laws of local towns, rather than national laws. But in the 13th and 14th century, with an increase in trade, followed by scarce supply of skilled workers due to the Black Death, this created an impetus for an increase in the number of guilds. This, in turn, would increase the need for national laws addressing guilds, rather than a reliance on local laws to govern guild activities. There's no debate that guild laws influenced competition and thus may be considered under the umbrella of competition laws. However, there is a significant debate regarding the power and effect of guilds on competition in the market. The classic position is that guilds were anti-competitive, rent-seeking monopolies that sought competitive privileges from the state. This view gained prominence with the publication of Adam Smith's Wealth of Nations and has continued to present. There are some records which indicate that there was, at times, a public perception that guilds were harmful to competition and caused prices to go up, such as the complaints against the Weavers' Guild in London in 1321. However, some commentators have questioned the extent of anti-competitive effects on guilds. So we'll take a look at those secondary sources where we have some scholars taking a look at guilds and arguing one way or the other that guilds were anti-competitive, or perhaps that guilds did not have that effect on competition laws. And that pretty much would end the period that we're looking at in the Middle Ages. But it does lead to a very interesting segue into the Renaissance period, where guilds continue to be a concern with respect to competition law issues. And so with that, we'll see if we have any questions.
That was marvelous. So it usually takes folks a second, so I'll slip in a question. How do you distinguish between laws that are competition laws versus laws that are aimed at charity? So when you were talking about Joseph and the grain laws, I thought of the provisions in Hebrew scripture that said you cannot harvest the edges of your field so that they're available for the poor to glean. Is that competition law, or is that something different?
Well, it could be looked upon as not necessarily competition law, but economic thought relating to competition issues. And so with the competition laws, for example, with respect to laws against forestalling, regrading, and engrossing, we see biblical pronouncements, which are then interpreted in the Talmud. And when they're interpreted as being God's law against these particular practices, it would fall under a religious law, canon law, perhaps later on, Hebrew law in this context. But when we're taking a look at certain economic thoughts that have not been interpreted as such, oh, this is God's word against forestalling. This is instead an economic thought that it is better that we have some grain left for the poor so that they will not be hungry. So, and the economic thought behind that is boiled down to its very basic component. Hungry people get angry and they create political unrest, and we don't want them angry. So the economic thought is, isn't it best to figure out some way in order to make sure that we don't have this economic instability leading to political instability?
Oh, excellent distinction. And I see in the chat, we have a question. Are we going into ancient palace economies and how they evolved?
Ancient palace economies will be discussed and how they evolve with respect to the, and in particular, also we have ancient and Middle Ages estate economies and how they basically evolved the local market laws that we were talking about just a few minutes ago here. So how did they evolve with respect to how were they able to regulate prices and to regulate who could harvest, when they could harvest, what they would have to take, what they'd have to give in for taxation, and if there were any prices that had to be followed with respect to these local ordinances by estate laws or ancient palaces.
Excellent. Is there anyone who wanted to unmute and ask something? Griffin, did you have a question?
Yeah, my question is, do we need to have a type of, background for understanding the context of this time period to take this class, or are we okay not having taken history classes for this period prior?
You're fine with not having a background in the historical periods because I will be discussing and providing that. You're fine with not having a background in economics because I will be discussing and providing background information for that so that this will all make sense. You're fine with not having a background in antitrust law, or as most of the world calls it, competition law, because again, I will be providing a background to that to give us context with respect to the materials that we'll be looking at in great detail.
Okay, thank you.
Anyone else who'd like to ask a question? There's so much food for thought in there. And always good to see Aristotle's ethics being flogged. I was just telling my university perspectives class that after the Bible, it is probably the most influential text in Western culture.
Some would argue Adam Smith's Wealth of Nations, but I won't go there.
I had a seminar as an undergraduate where we read all of the theory of moral sentiments. I think that at least got me out of a lot of purgatory time.
We will be taking a look at various sources, again, numerous sources, but not to cause any great fear, because it's not like, okay, here's Aristotle's ethics, read it all now. And by the way, you also need to know politics, and you also need to know all of these orations. We'll be taking a look at portions of it, but enough to give context to what it is that we're reading.
Is there anyone else who you can put your hand up, or you can simply unmute and or turn on your video if we have another question? Give folks a second for just to make sure. And to follow up on what Professor Foster said, in all of our signature seminars, it is our earnest desire to have students from as many different colleges and majors present so that the discussion is rich. And so you are being pulled out of your own comfort zones and into thinking about new things in new ways. So please do not believe that you need to be an expert in any field. You just need to come with an open mind and ready to work. So Catherine Sampson has a question that says, for the Middle Ages period, are you primarily looking at Great Britain?
First off, I'd like to say hello to my friend and colleague, Kathy Sampson. Thank you for joining us and for asking the question. No, actually, I do not plan to spend all of my time focusing in the Middle Ages in the United Kingdom. There are numerous sources that we will be looking at in that Middle Age period. Certainly, St. Thomas Aquinas was not from the United Kingdom, and yet offers us extensive materials for taking a look at this. And we will be looking at, it's primarily Western focused. I mean, we do not have a lot of sources that we will be looking at outside of continental Europe, including the present day United Kingdom. But we will be taking a look at many sources from continental Europe.
Excellent. Anyone else before we close things up for what has been a very entertaining evening? And I have had a whole string of comments saying, I have to leave early for my next class. I can't wait to see the video, and I will be talking about this with my students. So I think that we can give no higher praise than the obviously high degree of audience satisfaction. Please join us next week when Sandy Edwards of Crystal Bridges will be joining us to talk about her course, Inspired. If you have any further questions, feel free to email me I will put my email into the chat. And this video should be going up in a couple days for you to look at. So once again, thank you to Dean McCabe, and especially thank you, Professor Foster, for a fantastic talk. And we will look forward to seeing the seminar this spring. Good night, everyone.
Thank you.
Thanks, John. Thanks, Professor Foster. Really terrific.